Hi, KP. Thank you so much for agreeing to do this interview. Before we get started with the questions, can I just ask you about your profile and what is it that you do?
Hi, I am a lawyer with about 13 years of experience in the profession. Presently, I am a partner at the office in Delhi. And all these years, I think most of the work that I've done is on the commercial dispute side, be it dispute prevention advisory or be it dispute resolution, either in mediation, arbitrations, both domestically and international arbitrations. And also a lot of work on the regulatory side, which again involves a lot of interpretation of the provisions of a contract or a license, which is in some sense, again, a contract. So this is what I've been doing.
All right, great. So I'll dive right into it. KP, can you tell me what is a force majeure clause in a contract?
Then a party who is unable to perform its part of the contract because of those events listed under a force majeure clause can claim non-performance of the contract that period that the force majeure is in place, and also in certain events force majeure clause can lead to frustration of the contract. Now this is where force majeure is part of the contract. However, force majeure as a doctrine is well understood. And Section 56 of the Contract Act has certain elements of it, although force majeure clause, force majeure is not defined under the Indian law.
Okay. So, so if a force majeure is not in a contract, can the doctrine still be invoked?
Yes, the elements are already, as I said, you can find it under Section 56. So it can be invoked by certain parties, but of course it has to be seen in the contract, in the context of the contract, and whether that event has happened, which will make it impossible for a party to perform a contract, and whether they can, in those circumstances, claim force majeure. So, but I do want to put it, I think most beautifully put it by Justice Simmons, when he said that disappointments will not lead to disappointed expectations will not lead to frustrated contracts. So you have to keep that in mind, that a force majeure clause could be triggered on us on certain disappointments, but it does not mean the contract is frustrated. So there are two elements of force majeure, as I said. A, suspension of your performance of a contract during the force majeure event is alive. And two, whether a force majeure event will ultimately lead to termination of a contract.
Okay, fair enough. So how and when can a party invoke force majeure clause?
So I think at the very instance where a party is unable to perform its contract, that's force majeure, which is unforeseeable or which is listed in a contract. So any event which would come in and which will make it a performance of a contract impossible, that is force majeure. And the party should invoke the force majeure clause at the very first instance. The moment a performing party under a contract realizes that it is not able to perform its part of the contract, it should inform or put to notice the other party that, and listing out, and they must list out that what are those events they should identify very clearly and specifically, and put it in the context of the contract, that this event has happened, which is a force majeure condition, and we are not able to perform our contract. Now, as I said earlier, there are two elements to it. A, by claiming force majeure, you can either claim suspension of your performance during the force majeure event, or you can claim frustration of a contract. So those two are very different things. And if you are invoking force majeure clause, putting the other party on notice, you should be very clear that what is it that you are asking for. You're asking for suspension of performance, or you're asking for frustration. Now, it could also be, there is a third element I would add to it, is possible that where party is asking for suspension under a force majeure clause, and the force majeure is prolonged beyond what they have anticipated at the time of putting the other party to notice, it may ultimately lead to frustration.
Okay. Can a party take advantage of a force majeure clause if in the definition, the agreement, if in the definition, the clause is quite limited and does not include something like a pandemic or COVID-19. Can a party still take advantage of the provisions of that contract?
Well, that's a very interesting question. Usually, you will find in various contracts there is a force majeure condition. There's a force majeure clause already, and they define the boundaries of that force majeure. But I think any event which the doctrine of force majeure is any event is unforeseeable by the parties. If it is triggered, which prevents a performance of a contract, is a force majeure event. So even if you have defined it in your contract, then I think still you can invoke a force majeure condition which is beyond that clause. However, there could be certain subset of contracts where parties have been very clear on their obligations, in the sense that they could say that we have defined these 10 force majeure conditions, and then there's further clause that says that anything beyond this cannot be treated as a force majeure condition. I think those contracts and those clauses will be fairly limited. There could be a debate that even if there is a situation where parties actively or by their own volition have understood the risk that is involved, that apart from these conditions which are contained in a force majeure clause, no other condition can be a force majeure. So, but that very limited subset in the contractual world. But I think any condition, the principle is any condition which would make it impossible for you to perform a contract is a force majeure, and it can be invoked by a party, even if it is not mentioned in the specific force majeure clause.
Okay. So the very basic question is, can COVID-19 trigger force majeure?
Well, that's again a very tricky question. In fact, there is some confusion which has occurred because of the 19th February 2020 order by the Department of Expenditure, Ministry of Finance, which has said that COVID under their procurement manual would be a force majeure event. Now that has been widely circulated, and probably that's an impression that Government of India has declared COVID as force majeure, and probably that's universally accepted and applied. But that is not the case. In fact, that office memorandum clearly states that it is only for the procurement of goods and services by the government under particular manual, and wherever they are suppliers or they are taking supplies from somebody, they can claim force majeure, COVID as a force majeure condition. But under other private contracts, whether COVID is a force majeure or not, of course, that has to be looked into. In my view, COVID can be treated as a force majeure event even under the private contracts. But then again, as I said, there are two roads which you have to take while invoking force majeure. A, whether are you asking for a suspension of your performance during the force majeure event, or are you asking for frustration? Now, these two events have to be looked at from the perspective of your contractual terms, the nature of performance that you're supposed to do, and whether COVID can be a force majeure either to suspend your performance or to frustrate the contract altogether has to be looked at from each contract's perspective.
I just want to ask a question on a very specific kind of contract. There's a lot of people asking about it. Does COVID-19 trigger force majeure in a lease agreement? And if so, what are the implications?
Yes. So generally, force majeure under the lease agreements, and in fact, leases generally are governed by their own provisions and also the provisions of Transfer of Property Act. So whether a force majeure is as we understand under the Contract Act, would also apply to a lease, is at least under the Indian judgments or Indian law that has been laid by the courts, has been held that leases are generally governed by the provisions of the Transfer of Property Act. So a force majeure condition, as we understand in the contractual realm, may not apply to leases because Section 108 of the Transfer of Property Act provides for conditions where certain leases can be terminated where the substratum of the contract, which is the leased property, if let's assume it doesn't survive, then of course lease is to be terminated. So that may not fall under the realm of a force majeure under the Contract Act, but would be governed by the provisions of the Transfer of Property Act. So COVID, whether it will fall under force majeure or not, as I see it, it may not. It has to be looked at from the each lease agreement and also the provisions of the Transfer of Property Act. Now, as I said, that force majeure has to be looked at from two angles. One is performance and one is frustration. Same as for lease. If let's assume that lease is only for a very short period during which the restrictions of COVID are in place, then clearly the lease could never trigger, and that's a force majeure event. However, where leases are for a specific period and out of that period, for certain for a large leases for a large period, and out of a certain period, you're not able to access the property that you have leased for. So that is where it has to be determined by the terms of the lease. If the lease says that let's assume a commercial lease, and you're not able to use that property for any reason, a lease may contain a condition that no rent is payable during this period. But if not, then that's the question that I think is very open-ended and has to be tested.
Thank you so much, KP, for answering all our questions. And we hope to see you on this forum again.
Thank you. Thank you so much.